A 73-year-old retired bus driver in Georgia spent 38 years married to the same woman. He had a pension of $2,100 a month. She had Social Security. Between the two of them, they were comfortable. When his Parkinson's disease progressed to the point where he needed full-time nursing home care, they did what most couples do. They spent down their savings, applied for Medicaid, and assumed the hard part was over. Nobody told them about the pension. The day Medicaid approved him, the state calculated his share of cost, $2,100 in pension income, minus a $50 personal needs allowance. Every month, $2,050 went directly to the nursing home. Not to his wife, not to their daughter, to the facility. For 2 years and 4 months, his wife lived on her Social Security check alone. When he passed away, the state of Georgia filed a Medicaid Estate Recovery claim against his estate for $112,000. His family had 60 days to pay it, or the state would force the sale of the home, a house they had owned for 26 years and paid off entirely. Their daughter could not pay it. The house sold. After the recovery claim, the commissions, and the closing costs, she received $81,000 from a home her parents spent a lifetime building. 3 documents filed before a specific 5-year deadline would have protected that house entirely. Today, I'm going to show you exactly what those documents are, who needs them, and what happens to your family if you wait too long to file them. This video is for educational purposes only and is not tax or financial advice. Consult a qualified tax professional or elder law attorney before making any decisions about your specific situation. My name is Mark. Every week, I break down the tax rules, the financial traps, and the legal instruments that protect retirees from the things nobody else is explaining, especially the things the government is not going to volunteer. If you have a pension, if you own a home, and if you are over 65, this channel exists for you. Hit the subscribe button right now and turn on notifications so you never miss a video. The program that took that family's home has a name most retirees have never heard. It is called the Medicaid Estate Recovery Program. And if you have a pension and you do not have these 3 documents in place, it is already pointed at your estate. Let me explain what MERP actually is, because most people, including most financial advisors, have a dangerously incomplete picture of it. When a senior enters a nursing home and qualifies for Medicaid to cover the cost of that care, most people assume the story ends there. Medicaid pays the facility, the family keeps the house. The pension keeps going to the spouse. That is the assumption. That is not what happens. Here is what actually happens. The moment your spouse enters a Medicaid-funded nursing home, their income, their pension, their Social Security, nearly all of it, is redirected to the nursing home as a mandatory payment. It is called the share of cost, or patient liability, depending on your state. The state calculates it by taking total monthly income and subtracting a personal needs allowance of somewhere between $30 and $60. Everything else goes to the facility, not to you, not to your children, to the nursing home, every month until death. That is the first wound. The second wound comes after death. Federal law, not state law, federal law, requires every state in the country to operate a Medicaid Estate Recovery Program. The state is legally mandated to file a claim against the deceased Medicaid recipient's probate estate to recover every dollar it spent on their care. The home your family paid off over 30 years, the savings account, the assets that were supposed to go to your children, the state files a lien, and your state pays the bill. 2 wounds, one while you are alive, one after you die, and millions of retirees are walking into this with no protection in place because nobody explained it to them. There are 3 documents that change this outcome entirely, but, and this is the part that matters, they only work if you put them in place before a specific deadline. Miss that deadline, and the documents cannot help you. In some cases, filing them after the deadline makes your situation actively worse than doing nothing. Let me show you what each path looks like in real numbers. Let me be direct about how to rank your options. If you are in your early to mid-60s and in reasonable health, the Medicaid Asset Protection Trust is your most powerful tool and the one with the longest lead time. An elder law attorney drafts the irrevocable trust. You transfer the deed and the 5-year clock starts. The legal cost is typically $1,500 to $3,000. a one-time investment that protects an asset that in most markets is worth $200,000 to $500,000. This is the option you want. Do not wait for a diagnosis to pursue it. If you are already inside the 5-year window, if nursing home care is a near-term reality, the MAPT is no longer available for the home. In a small number of states, primarily New York, an option called spousal refusal allows the community spouse to legally refuse to contribute their assets to the cost of care, forcing Medicaid to cover the resident while the state pursues a separate legal action. This is a contested strategy. It requires experienced elder law counsel. It is not available everywhere. Do not attempt it without an attorney. Federal Medicaid law also contains specific transfer exceptions that can allow the home to move to certain family members without triggering a look-back penalty. The Caregiver Child Exception applies when an adult child lived in the home and provided care that demonstrably delayed nursing home placement by at least 2 years. Documentation requirements are strict: medical records, care logs, physician statements. The sibling exception applies when a sibling with an equity interest in the home has lived there for at least a year before institutionalization. These exceptions are real, they are legal, and most families never know they exist. The worst option is to do nothing and assume Medicaid will handle it. It will, but on the state's terms, not yours. The pension disappears. The savings are spent down. The state recovers from the estate. Your children inherit the debt. Here is your action checklist. 6 things to do this week. 1. Go to NALA.org. That is the National Academy of Elder Law Attorneys, and search for an elder law attorney in your state, not a general estate planning attorney, not a financial planner, specifically an elder law attorney who handles Medicaid planning. The practice area requires specialized knowledge that general practitioners often do not have. 2. Before your first appointment, pull together your income picture. Every source of monthly income for both spouses, the amounts, and whether those sources are pension, Social Security, annuity, or other. Know your combined monthly total. Your attorney will compare it against your state's Medicaid income model on the first call. 3. If you own real estate and you are more than 5 years from a likely Medicaid need, ask your attorney specifically about a Medicaid Asset Protection Trust for your home. Get a written quote. Compare that number to the value of your property and to the MERP claim your estate would face without it. 4. Ask your attorney directly. Does my state use an income cap or a spend-down model for Medicaid long-term care? If your state uses an income cap, ask whether your current income exceeds $2,829 per month. If it does, ask about a qualified income trust before you need one. 5. If your spouse is already in a nursing home or approaching admission, request a formal community spouse resource assessment in writing. Today, not after the spend-down begins. You are entitled to this under federal law. Your attorney files it. It establishes the protected amount before Medicaid calculates what you owe. 6. Do not transfer any assets without legal guidance. A transfer made inside the 5-year look-back window does not protect those assets. It creates a penalty period calculated by dividing the asset's value by your state's average monthly nursing home cost. On a $280,000 home in a state where nursing home care runs $7,500 a month, an early transfer creates 37 months of Medicaid ineligibility. That is 37 months of nursing home. Bills your family pays out of pocket. Medicaid is not a gift. It is a loan the state collects from your estate after you die. The pension your spouse earned over 30 years does not belong to your family the moment they enter a nursing home. It belongs to the facility 1 month at a time. The 3 documents in this video exist specifically to change that outcome, but they only work if you file them before the 5-year clock runs out. After that, you're not planning. You are just watching. This is Mark. If this video helped you, hit the like button right now. It takes 1 second and it helps this video reach more retirees who need to hear it before the window closes for them. If you are not subscribed yet, hit subscribe and turn on the bell so you do not miss the next one. If you know a retiree who has a pension and owns their home, send them this video today before the 5-year window closes for them. Drop a comment below. Do you or someone in your family already have a Medicaid Asset Protection Trust in place? I read every single one, and the most common situations become future videos. I will see you in the next one.